Now, consider what happens when A and B have a dispute between them, but they call upon the Supreme Court to review a case that it has already decided involving C and D. Now, what do these separate sets of parties have to do with one another? Absolutely nothing. But as it turns out, in Nedbank versus Nkambule, the Supreme Court judgment brought on review a 2021 case of Cashbuild, Swaziland versus Nkambule. Now, bear in mind that the Cashbuild judgment was delivered by a full bench of the Supreme Court. In other words, there were 5 justices sitting to hear that matter. Now, those 5 justices made a ruling in that particular matter. In essence, Nedbank versus Nkambule was concerned with the legal correctness of the Cashbuild judgment. That's the first thing. The second thing they were concerned about in that particular case was the hierarchy of the High Court and the Supreme Court on the one hand, and the Industrial Court and Industrial Court of Appeal on the other. Now, the court makes the following disclaimer before considering the issues. The number of justices that were in the Supreme Court was limited at the time. Let's just say the number of Supreme Court justices are limited in number, as we know that to actually be the case right now in the Eswatini jurisdiction. So when you bring a review of a Supreme Court judgment, the second panel will likely have members from the first panel. Anyway, on a basic view of the case law, what was so wrong with the Cashbuild judgment? So Nedbank says the Cashbuild case basically created a legal cul-de-sac which prevents litigants from pursuing labor matters in the High Court and the Supreme Court. Now, you may be asking yourself, why pursue a labor matter in the High Court or the Supreme Court when Eswatini actually has a specialized industrial court and an industrial court of appeal? Well, I'm wondering the same thing, but feel free to leave your thoughts in the comments section. And so buckle up as we dive in. Welcome to the Nkantolo podcast. This is season 1, episode 5. My name is Vili Mile. Let us begin with a summary of the facts. So let's start with Cashbuild versus Nkambule. Now, the employer in this particular case, Cashbuild, holds a disciplinary hearing against Nkambule. Nkambule is then subsequently dismissed from her employment. She approaches CIMAC, that would be the Conciliation, Mediation and Arbitration Commission. Then CIMAC issues a certificate of unresolved dispute at the mediation stage. The matter is then referred, or rather the matter goes to the Industrial Court, which orders that Nkambule must be reinstated and compensated on the basis that her dismissal was unfair. Cashbuild then approaches the High Court to review the order of the Industrial Court. The High Court dismisses the review application and confirms the legal position held in the Industrial Court judgment. Now, dissatisfied with both outcomes, Cashbuild then approaches the Supreme Court, which is the apex court in our jurisdiction. And then Cashbuild is unsuccessful there as well. Nedbank then brings a review of the Supreme Court judgment in terms of Section 148, subsection 2 of the Constitution. Now, we're not going to cite it, we're not going to read it. Just bear in mind that this is then a second review which is sought in respect of the Supreme Court. In other words, the Supreme Court must be reviewing itself. The Supreme Court then directs the parties to file written arguments and then postpones the hearing so that it can sit and hear the merits of the review application. So let us pause for a second and consider the legal questions that arise from this scenario. 1. Does the Supreme Court have power to supervise itself in terms of Section 148 sub 1 and sub 2 of the Constitution? Well, I recently attended a case in the Supreme Court, and there was a discussion there about the fact that the supervisory jurisdiction is quite peculiar to Eswatini as a jurisdiction, and that other jurisdictions that have a similar mechanism of self-review contained in their constitutions, maybe the other one would be Ghana. We don't really see other examples of self-review being contained in the constitution. They're there, but it's just not something that's common in legal jurisdictions, in Roman Dutch common law jurisdictions, in Africa anyway. The present court answers this question by saying no. The basis for the answer is that the 2019 judgment of Tsuelo Health versus Rivi entrenched the position that the Supreme Court is not a court of first instance. So the present court then further relies on sections 146, 147, and 151 of the Constitution. These deal with jurisdiction in the main, which hold that the Supreme Court is a final court of appeal, just as the name suggests. Now, the Supreme Court is a creation of the Constitution, and as such, it may exercise appellate, supervisory, and review powers in terms of the Constitution. Now, interestingly, the first review raised a constitutional issue, wrongly so, and this was found by the second review court to not really align with the law. As such, it was reviewable and had to be set aside just on that constitutional consideration alone. Now, the constitutional issue would have had to be raised in the High Court. This is what the court found, the Supreme Court found, sitting now in the second review. The constitutional issue would have had to have been raised in the High Court, which actually had constitutionally endowed original jurisdiction. So we see a very interesting interplay between appellate jurisdiction on the one hand and original jurisdiction on the other. So here comes the second question. Let's move on to the more interesting second question, which was determined by the first review. Now, the question simply says, does the High Court have power to review decisions of the Industrial Court and the Industrial Court of Appeal? Well, I recently had occasion to just scan through a judgment by the learned Justice Masego, who is a High Court justice in the Kingdom of Eswatini, making reference to these two cases of Nedbank and Cashbuild. And let me save that for a different episode so that you'll just come back and have a look at that. So here's the principle that was distilled. In terms of Section 152 of the Constitution, the High Court has inherent power to review all decisions made, and here's the key, by subordinate courts. Now, naturally, we must ask this follow-up question, as the court did. Are the industrial courts subordinate courts? I'm asking a question that really carries twins, perhaps not twins, but when I say industrial courts, I'm invoking both the industrial court and the industrial court of appeal. This is the question that the court was seized with. Does the High Court have powers to review decisions that are made by these as subordinate courts? Now, in the case of Cashbuild, the court simply answered the question by saying no. They are rather specialized courts established in terms of Section 139, subsection B of the Constitution of the Kingdom of Eswatini, 1 of 2005. Now, what the Supreme Court found this to mean in Cashbuild is that the industrial court is equivalent to the High Court, and the Industrial Court of Appeal is equivalent to the Supreme Court. So the distinction there is clearly being drawn not on the idea of being subordinate, but on the idea of being specialized. Now, the distinctive feature of the industrial courts is therefore that they enjoy exclusive jurisdiction. Now, a constitutional question was therefore answered in Cashbuild, Section 19, subsection 5 of the Industrial Relations Act, which provides that the industrial court's decision is reviewable in the High Court, was actually declared to be unconstitutional. Now, it is important to note, however, that there was a dissenting judgment in Cashbuild, which held the view that these courts are simply not equal. And so, on the one hand, one is a specialized court, whereas the other enjoys unlimited jurisdiction in all civil and criminal matters. So the view offered in the dissenting judgment was that the High Court outranks both the Industrial Court and the Industrial Court of Appeal. So let us then maybe have a look at the third question. The third legal question then is how many reviews are permissible in terms of Section 148, subsection 2 of the Constitution. The reality is that from the judgments made by the Supreme Court, there are essentially two schools of thought. One school says there can only be one review, whereas the other school says there can be more than one review if an application to pursue the review is granted. Authority for the second school of thought includes the 2017 judgment of Dlamini versus Bennett and the 2019 judgment of Henwood versus Henwood. Then a fourth legal question arises. I've couched it as follows. Is it in the interests of justice to review and confirm or set aside Cashbuild in the present application, which is between Nedbank versus Nkambule? In other words, can this set of parties invoke facts that were considered by by the same court under different facts and circumstances? To put it blankly, they're not parties to the same litigation that was decided. Can they ask the court to review that other decision in respect of other parties? Well, our Supreme Court had the following to say, and I'm quoting this verbatim from the judgment. The courts are legally enjoined to hear and resolve disputes between parties and not to engage in colorful academic discourse leading to nowhere. The Supreme Court in this case, however, found that it was, of course, in the interests of justice to review and confirm or set aside the Cashbuild judgment. So one of the most important pronouncements of the Supreme Court in this very Nedbank versus Nkambule case relates to the concept of legal certainty, which if you're a law student, you might have already encountered in your legal studies. So I quote what the court said verbatim, and I believe it should be of interest, maybe to lawmakers or the legislative arm of government, given that there are two differing schools of thought on the same issue. Here's what the court said. It said, after more than 15 years from the promulgation of the Constitution, there is neither an act nor rules operationalizing Section 148 as envisaged by the Constitution. Hence the inconsistencies. These inconsistencies harm our justice system. This is still the court speaking. Any day that goes by without the envisaged act or rules is one day too many. Then the court says, hopefully the participation of the Attorney General in these proceedings will result in some impetus to resolve this legal anomaly. Now, having dealt with the court's construction on Cashbuild, we now move on to consider the present case, which was then between the parties, Nedbank and Nkambule. So Nedbank says the decision in Cashbuild was wrong. The Supreme Court misdirected itself and it should be reviewed and simply set aside. The Attorney General actually agrees with the bank, with Nedbank in this case. Nkambule, on the other hand, says there's no merit to the second review application, and as such, it should be dismissed. Now, in analyzing Nedbank's case, the court draws the important distinction between the process of appeal and the process of review. Pick up any law book, such as Pate and others, on civil procedure, and just try and read up about appeals, and you'll see that one of the most written about subjects in the area, perhaps just of appeals, is the distinction between an appeal and a review. Now, if you have an understanding of these two concepts, be sure to leave, a comment in the comment section. Anyway, let's hear what the distinction, the Supreme Court drew between these two concepts. Here's what the Supreme Court held. It says appeals are broadly necessary when there is a question regarding the correctness or incorrectness of a decision. The genesis of an appeal is usually statutory. Review, on the other hand, is an inherent power that exists at common law level. So let's go down memory lane now and join the Supreme Court in a short list of its own decisions. Here's the summary that comes to us from the case of Nedbank. Buckle up, because this episode is a little bit longer than the 10-minute ones that you've seen in previous episodes. A, in 1997, the judgment in Dlamini versus President of the Industrial Court says that the High Court does not have appeal jurisdiction, but that it does have review jurisdiction over the High Court. B, in the year 2000, this position is confirmed then by the judgment in Madiwane versus Central Bank. C, in 2006, the Supreme Court holds that it does not have jurisdiction to hear appeals from the Industrial Court of Appeal. This was in the case of Swazi Observer versus Ngwenya. D, in October 2016, it is held in the Ezulwini Municipal Council versus presiding judges of the Industrial Court of Appeal that the Industrial Court of Appeal decisions are reviewable by the High Court. Then E, in November 2016, the Supreme Court confirms that decisions of the Industrial Court are reviewable in the High Court. This was in the case of Dube versus Ezulwini Municipality. Then F, in September 2018, this was in the case of SRA versus presiding judges of the Industrial Court of Appeal. Now, this case confirms that judgments of the Industrial Court of Appeal are final, and therefore they are neither appealable nor are they reviewable in the High Court. This case did not necessarily answer the question whether the High Court in particular has jurisdiction to review the Industrial Court's decision. It rather remained silent on the issue. Then G, lastly, in this short list, in November 2018, the judgment in Aveng Infraset, Swazi versus Dlamini, the court basically said that the Industrial Court of Appeal's decisions are reviewable by the High Court. And that was, in this synopsis that was given in the case of Nedbank, the last case in terms of that timeline between 2016 and 2018. So we've gone down memory lane with the court. We now invite you to obviously then make up your own mind and let us know in the comments what you think about this particular history. So the Supreme Court goes just a step further and considers decisions of other jurisdictions other than Eswatini, and these being Botswana, South Africa, and Lesotho. Now, what's common about these three jurisdictions is that they subscribe to the Roman Dutch principles. They operate on the Roman Dutch law, the English common law. Obviously, there's a myriad and there's some, slight variances here and there, but the legal systems are quite similar. And there are, in fact, specialized courts to deal specifically with labor issues in all three of these jurisdictions. So without citing the authorities, the court then finds the following position in respect of each country. 1, in Botswana, the Industrial Court is considered a subordinate court. 2, in South Africa, the High Court enjoys concurrent jurisdiction with the labor courts in labor disputes. 3, in Lesotho, the Labor Court and the Labor Appeal Court are not inferior courts as they enjoy exclusive jurisdiction in respect of labor matters. So, in its conclusion, the court concedes that there is a lack of consensus in the Supreme Court. The court in Nedbank versus Nkambule nevertheless finds that the court in Cash Build had no right to declare Section 19 sub 5 unconstitutional. So you may be wondering, just as I am, why? Because on the fundamental doctrine of separation of powers, that is considered to be judicial overreach and is not legally permissible. So the court placed the Attorney General as the key role player to consider the issues raised in Cash Build, to evaluate the efficacy of the law, and to make recommendations for legislative interventions. The Supreme Court's decision in Cash Build was therefore reviewed and set aside. It was then confirmed that the High Court indeed has powers to review the decisions of the Industrial Court and other forums. Nedbank and Nkambule were granted leave to proceed with any other matters in the courts, which were held up by the determination on the Cash Build review, and then there was no order as to costs.